This conference will now be recorded.
Okay, well, I would like to go ahead and get us started so that we can make the best use of our time. For those of you who don't know me, my name is Jim Doberstein, and I'm the president of the board of directors for the Texas Association of Environmental Professionals. I am thrilled that we can do this today. Thrilled to be able to join you from my home office, so I'm excited about that. I'm glad Matt was very gracious to be willing to join us today and make this presentation. I'm thrilled that we have so many people that are interested. I hope everybody is doing well and transitioning this current environment to the best of your ability. I know it's been tough for a lot of my colleagues in a lot of sectors, but I hope that you're making that transition and things are looking up as we're moving forward. Thrilled again that you can join us and we can kind of keep the collaboration and opportunity to share good information with each other in a real time frame alive. So I'm really excited about that. I want to also mention that we intend to continue to offer these, and this was my name, by the way, virtual brown bag luncheons. I'm very proud of that. We do intend to continue to do this on a monthly basis, at least until we can resume our regular face-to-face luncheon meetings. I anticipate we may restart those in the summer. However, depending on the interest in this platform and how things go in terms of our ability to manage it, I anticipate we will continue to do some webinar-based presentations, either in addition to our regular luncheons or on specialized topics, or potentially to supplement those. And this could offer us an opportunity for people to participate who wouldn't otherwise be able to get into a luncheon meeting, actually to get into downtown. So we are looking at those kinds of opportunities. If you have any comments or suggestions, feedback on how this goes today, I would love to hear from you. You have a lot of ways to reach us. You can reach out to Craig Klein, who is our webmaster, and he's been giving us some instructions this morning. You can reach out to myself directly at president@taep.org. You can reach out to our general email address at taep@taep.org as well, and we would be happy to hear from you, and that would give us some good feedback. You know, TAEP is an all-volunteer organization, and we really appreciate your patience as we've tried to transition this and figure out a way to get back up to speed and reach out to you. We are pleased to let you know that we are continuing to do work in the background. We have been offering scholarships, for instance, during the spring to students, some of whom were displaced as a result of this virus. So, of course, we really appreciate your membership. If you are a member of TAEP and are joining us today, we greatly appreciate your membership. Those membership dollars help us not only transition this time when our revenue is down, but also allow us to continue to serve our mission, to provide information to you, provide a platform for collaboration and networking, but also then to serve students who are trying to enter the field as well, which is a really big part of our core mission. So we really appreciate that. If you are not a member and you are joining us today, we would like to welcome you. Very happy to have you, and we hope that you would consider joining us moving forward. Our membership rates are very low, and there are benefits to being associated with the Texas Association of Environmental Professionals. Most recently, we opened up a new jobs board for posting positions or posting your resume if you're looking for work. And we think that it expands significantly on what we've been able to do in the past. So I'm really excited about that as a membership benefit. So we would certainly welcome that. And of course, we always welcome sponsorships and donations towards our scholarship programs, which would allow us to continue to do that. So if you are so inclined, you can reach out to me or reach out to Craig, and we can direct you in that end. So I am going to step aside and so that our speaker can share his presentation with you. But I want to give Matt a short introduction. So I've known Matt Stahman for a number of years, and he currently is serving as the Director of Regulatory for Resource Environmental Solutions, which you may know as RES. He's been in that position since 2017, and he also manages one of RES's largest permittee responsible mitigation sites, a 15,000-acre habitat restoration to offset the impacts at the Bull d'Arc Lake Project in Fannin County, northeast of Dallas. He was previously scheduled to actually give us a presentation on this particular restoration effort, and I'm hoping, Matt, maybe sometime you'll come back and be able to do that for us, because I would personally be very interested in that with my particular background in habitat and wetland restoration. He formerly served as the principal of SWCA Environmental Consultants Houston and Baton Rouge offices, and that's actually where I met Matt. And he was with SWCA for 15 years. He has over 20 years of experience with Clean Water Act permitting, Endangered Species Act consultation, and NEPA environmental impact assessments, among other things. He graduated from Texas A&M University in 1996 with a bachelor's degree and master's degrees focused on wildlife management and wetland ecology. He has worked throughout the United States, has a very deep background in the wetland scientists. He is a registered professional wetland scientist with the Society of Wetland Scientists South Central chapter. And well, I'm going to let you take it from there, Matt. I really appreciate, on behalf of TAEP and our membership, your willingness to present to us in this venue, and we welcome you here. I would remind everybody that if you have questions for Matt as he is presenting, there is the chat feature. We will be monitoring the chats, and when we get to the end of the presentation, I will be reading out a few of those questions where they kind of cover the bulk of the questions, and then we will also be going back and looking at questions we couldn't get to, and then providing a written response that we'll email out to all the attendees over the next week or two. Matt, it's you from here. Thank you so much again, and welcome.
All right. Thank you, Jim. Can you hear me okay? Making sure this is coming through.
Yes, I hear you great.
So I'm sitting like most of you in my home office. This is just quite a surreal experience. I really appreciate being invited to give this presentation. But don't be surprised if you hear a dog barking or door slamming or whatever. I'll try to stay as quiet in the background as we possibly can. Let's see, Craig. I guess I need to share my screen now and get the presentation up.
Yep, that should do it. Are you having problems? Maybe I need to give you.
Yeah, it says you got to make me the presenter, I think is what it is.
Bear with me a second, Matt.
No problem.
It's alphabetical, of course.
Yeah.
What would life be without some technical issues? Try it now. That should work.
I am now the presenter. Very good. Okay, so I should be able to share this thing and get us kicked off. Okay, great. Okay, I've kind of got my screen set up to where I'm mainly focusing on the presentation. As far as the chats are concerned, I think we'll probably save the questions for the end. A lot of material to cover, a very diverse audience today. So I'm going to start off by talking about a little bit of the past of how we got here with the definition of what is United States. Speak to the present situation, including the Navigable Waters Protection Rule that is slated to go into effect soon, and then talk about the potential future as we move forward under that rule and some of the potential litigation that's already lined up. So if you're a regulatory geek like me, this is just a heyday. I mean, there's so many fun things going on. with the Clean Water Act, depending on your perspective, of course. But for me, the debate and the constant churn of where jurisdiction lies just fascinates me, because I'm still 20 years and plus into my career. I'm still just amazed at the scope of the Clean Water Act and how we've been able to apply it on a landscape full of different aquatic resources. So it doesn't surprise me that we're still trying to debate the issue. So what I want to do today is I want to talk very briefly about the birth of WOTUS and Clean Water Act. I'll keep that very short because I know most of y'all are very familiar with this. I'm going to talk about the history of the waters in the United States, and the main Supreme Court cases that got us to this point. Talk about the Clean Water Rule and the Navigable Waters Protection Rule, because you can't really talk about one piece without addressing the others. All of these things have been iterative, so it really helps to know where it came from, and you can see terms and language as it moves through the entire the different phases, I guess, of defining waters in the United States. And then we're going to talk about the future, litigation, legislation, and the role the states may or may not play in the future protection of our aquatic resources. So let's start with the basics. Clean Water Act. As most of y'all are aware, the Clean Water Act dates all the way back to 1972. In fact, it probably dates back further into 1948 with the Federal Water Pollution Control Act. But the Clean Water Act, as we know it today, came into effect from the initial amendments to that Federal Water Pollution Control Act in '72, and then the Clean Water Act and the Water Quality Act of 1977 and 1987, respectively. All of this collectively is what's called the Clean Water Act as we know it today. The Act references waters of the United States over and over and over again. But that enduring question is, what exactly is a water of the United States? So I decided that, WOTUS sounds sort of negative. I like acronyms and everything, but WOTUS doesn't really have a very nice alliteration to it. So I thought we need to personify WOTUS in a more positive way, perhaps as a character of some kind. And so I took out my sketch pad one day, and I'm sitting there, I'm thinking about WOTUS, what WOTUS might look like, and I came up with this nice fuzzy little fellow. This is my embodiment of the WOTUS. Now, he may look familiar to you. Would not be surprised if he bears some resemblance to some character from a children's book. But this is the WOTUS, and I like to, the WOTUS likes to speak for the streams or all aquatic resources. Why is the WOTUS so important? WOTUS is important. Let's see if I can get this thing to go. There we go. Because WOTUS pops up everywhere in the Clean Water Act, in no less than 5 different sections pertaining to all different facets of Clean Water Act jurisdiction and regulatory authority. It references WOTUS, waters of the United States. Discharge of dredge or fill material under Section 404 is relevant to waters of the United States, all the way down to TMDLs under Section 303, and everything in between all references WOTUS. If you're looking for the extent of regulatory authority under the Clean Water Act, it is tied to this definition, and that's why it is so contentious and so important. It's been this way since the final iteration of the amendments to the Clean Water Act back in the 1980s, starting with Riverside Bayview. I'm going to talk about 3 main Supreme Court cases. Riverside Bayview, which helped define WOTUS in the 1980s. It was further defined in Swank in 2001, and then Rapanos in 2006. Tried to codify it into a rule in 2015 under the Clean Water Rule during the Obama administration, and then now trying to recodify it under the Navigable Water Protection Rule under the Trump administration. So let's look at some of those major actions. Riverside Bayview in 1985 was really where the Supreme Court first got involved with what was a definition of waters of the United States. Oddly enough, it was a unanimous ruling that and you wouldn't realize this before now, but at one point in time, people weren't sure whether or not adjacent wetlands were considered waters of the United States based on the way the Clean Water Act was originally written by Congress. This Supreme Court case made that decision. Yes, the Clean Water Act applies to adjacent wetlands. They are waters in the United States. Navigability in and of itself is not the main consideration that Congress was after when they wrote the Clean Water Act. And so adjacent wetlands, because they have such an influence on the physical, chemical, and biological integrity of our nation's navigable waters, they should be considered waters in the United States. Now, the case did not specifically discuss or take issue with isolated wetlands. However, during the proceedings of that case, the U.S. Attorney at the time mentioned that isolated wetlands would also be considered waters of the United States, as they were covered by the Commerce Clause of the Constitution. This was an interesting side note that was in the Supreme Court proceedings, not decided upon, but it set the stage for what would happen next. In the next year, EPA defined WOTUS, and they also then came out with what they considered to be what has been nicknamed the migratory bird rule, tying migratory bird use to interstate commerce for isolated wetlands and considering them waters in the United States at that time. So 1986, the first time WOTUS was defined. And actually, this is the definition that is still in place right now as of today, at least before the Navigable Waters Protection Rule goes into effect. In summary, that rule stated that waters in the United States included all navigable waters, territorial seas, things that you would think of as normal waters in the United States, navigable waters, whatnot. Their tributaries, impoundments, adjacent wetlands, and isolated waters that were somehow tied to interstate or foreign commerce. They did not get into the definitions of what it meant to be adjacent, what it meant to be isolated, and what exactly they meant by that tie back to interstate or foreign commerce. So the same year, the EPA issued this migratory bird rule. It was published in the Federal Register, and it gave justification as to why isolated intrastate non-navigable waters were covered under Clean Water Act jurisdiction because of their tie to the use by migratory waterfowl. Because migratory waterfowl were protected under the Migratory Bird Treaty Act, they were also hunted by waterfowl hunters, by duck hunters who would cross state lines and purchase goods and services in the act of doing that. That could be considered interstate commerce. That provided what the justification that the EPA needed to extend jurisdiction to those waters. And there were other things thrown into that migratory bird rule as well, including a tie to endangered species and use of water to irrigate crops across state lines that were sold in interstate commerce. But the main thing was its use by waterfowl. So these are what I like to call the salad days. This picture was taken a long time ago, and yes, that is me with a 50-pound GPS on my back. If any of you remembers doing field work with that equipment, we should have a happy hour at some point and pop a few Tylenol. That is the reason for my lower back issues today. But at that time, life was simple. All I had to do in my job as an environmental consultant at the time to help my client comply with the Clean Water Act was go out and delineate wetlands using the 1987 Wetland Delineation Manual. If the area that I found met the 3 criteria of the 1987 Wetland Delineation Manual, is a wetland. It was subject to Clean Water Act authority. If I found a channel, a tributary, a stream, and it had an ordinary high water mark as defined by the Corps of Engineers, that was also jurisdictional. And then, of course, all the tidal areas and navigable waters, they were all jurisdictional. Life was just so much more straightforward today, trying to decide what is jurisdictional and what is not. Why was it so easy back then? Well, back in those days, we had this permit called Nationwide Permit 26. Nationwide Permit 26 covered impacts or fill to isolated waters, including isolated wetlands, and headwaters, including headwater tributaries and streams. The limit on Nationwide Permit 26, at least up until 1996, was 10 acres. You could fill, in your single project, you could fill 10 acres of isolated wetlands and headwater streams, and there was no linear footage tied to the streams. It was all included in the acreage limit, without the need to go into the individual permitting process with the Corps of Engineers. This was a lot of leeway for projects. Eventually, that rule, or that nationwide permit, was challenged by environmental groups, and the Corps began to back it down, taking the impact limit down up until 1999, and then eventually retiring it in 2000. Well, then what happened after nationwide permit 26 was retired? The next year, another Supreme Court case came up challenging the limits of jurisdiction for the Corps and the EPA under the Clean Water Act. SWANC, Solid Waste Agency of Northern Cook County versus U.S. Army Corps of Engineers, decided that the long controversial migratory bird rule that roped in all those isolated waters was not valid. The isolated waters were no longer jurisdictional, based solely on migratory bird use. So after SWANC, if you guys remember, there was a lot of confusion. Now what do we do? How do we know where the Corps' jurisdiction lines, begins and ends? Where do we need a permit? Where do we not? The Corps began to really think, what does this mean? Which wetlands do we regulate? There was a lot of uncertainty on isolated waters and whether or not they could be considered because of some other connection to interstate commerce. And to the best of my knowledge, I did not see many districts that tried to make too much of an argument to tie isolated waters to other connections to interstate commerce at that time. In the Galveston district, where I'm most familiar, there was a big pullback on isolated wetland calls, and they developed this rule of thumb where if you were in the 100-year floodplain, if your wetland was in the 100-year floodplain or connected to the surface tributary system in some way, it was considered adjacent. Everything else was considered isolated, including hundreds and hundreds of isolated wetlands west of Houston on the Katy Prairie that the development community legitimately began to, on their properties, began to fill as quickly as they could in the state of non-jurisdiction as far as the Corps of Engineers was concerned. I remember as a young consultant, I began to panic. Do I still have a job? Is there any need to do these wetland delineations or whatnot anymore and deal with Corps of Engineers permitting? Why would you need a permit anymore? Those fears were quickly dissolved. Mitigation bankers, which I work for a company now that owns a lot of mitigation banks, began to wonder if they still have a market. And indeed, some mitigation banks did not move forward with markets, or it did have a considerable impact on their market. Some in lieu fees even ceased to exist in the mitigation realm because of their focus on mitigating isolated impacts. And the lawyers did what they did best. They litigated. And that brings us to 2006. 2006, the third in the trilogy of these Supreme Court cases, Rapanos, which most everybody is familiar with today. You guys know how that pretty much shook out. In a rare plurality decision, 4 of the justices sided with Justice Scalia's opinion in Rapanos relative to the definition of waters in the United States. And we'll go into specifics of the Rapanos case itself, but let's just focus on the outcome of it. Bottom line, Justice Scalia penned an opinion that limited waters in the United States to those waters that had relatively permanent flow or had some continuous surface connection with a water with relatively permanent flow. In Justice Scalia's opinion, the only things that Congress meant when they wrote the Clean Water Act and they used the term waters in the United States to be waters in the United States were normally flowing rivers and those wetlands that were immediately abutting and contiguous with those rivers, and then of course all of the tidal areas. So what you would think of as traditionally navigable and immediately abutting type features. There's a very conservative view of what would be a water in the United States. Justice Kennedy offered a concurrence with the plurality, and that concurrence was basically to vacate that case, the Rapanos case, back to its U.S. District Court for further consideration. But Justice Kennedy's opinion differed from Justice Scalia's opinion. Justice Kennedy said, yes, Congress meant all those waters that you just described, Justice Scalia, were waters of the United States, but they also meant something a little bit broader. And he brought in some of the statements that were made during the Swank case, specifically this phrase "significant nexus" as evidence to bolster his opinion, to justify his opinion. And he said that Congress really meant waters of the United States to apply to wetlands and water bodies that either by themselves or through some combination of those types of waters or similarly situated sites had a significant effect on the downstream physical, chemical, and biological integrity of our nation's navigable waters. That was Justice Kennedy's opinion. Combined with Justice Rapanos' opinion, go. Justice Stevens, who wrote the dissent, did not agree with either Justice Kennedy or Justice Scalia as far as the verdict was concerned. He felt that the Corps' jurisdiction post Swank should be left alone. That was something the agency should decide, and really they didn't need to go into that. But he did say that at a minimum, the tests that were put forward by Justice Scalia and by Justice Kennedy should be considered waters of the United States, if not more. But Kennedy and Scalia combined was at least the minimum threshold of what should be considered a water of the United States. So a lot of us were left asking this question after Rapanos: what does this even mean? How can we interpret this into boundaries of jurisdiction with the Corps of Engineers? And the Corps struggled with it for 2 years. The Corps struggled with it until they finally issued guidance in 2008 called the Rapanos Guidance, that went through these new categories and a new definition of waters of the United States after that Supreme Court case. I'm not going to even try to go into describing jurisdiction under Rapanos. I have some figures that I'll show you in a little while that kind of digest these things and compare between the different definitions of waters of the United States. So I'll let the pictures do all the talking. But we did come out with a whole new alphabet soup of acronyms from the U.S. Army Corps of Engineers: traditional navigable waters, or TNWs, relatively permanent waters, or RPWs, categories of waters that were meant to satisfy the criteria that were put forth by Scalia. And then there was a whole nother list of waters that were meant to satisfy Justice Kennedy's significant nexus test, or had to satisfy a significant nexus test in order to be considered waters of the United States on a case-by-case basis. And this went all the way up through the watershed to the very limits of streams and wetlands, and then into isolated wetlands, except those that had been clearly designated as non-jurisdictional by Swank. In the following year, or over the course of that year, the Corps issued a regulatory guidance letter to the districts, Regal 0701, that told them how to document jurisdiction. Regal 0701 came along with a 60-page jurisdictional determination form instructional guidebook that told Corps staff how to fill out an 8-page form for every water that they were assessing, water or wetland that they were assessing, as to whether or not the Corps should have jurisdiction in the post Rapanos world. This situation, or this process, became so involved and bogged down and burdened the Corps district staff so much that eventually the Corps decided that permittees who were coming in to get, either in a nationwide permit concurrence or an individual permit, could choose to either get an approved jurisdictional determination, whereby they would go through this full process, filling out these 8-page forms for each one of these waters involved in their project, and making a determination of where the Corps did and did not have jurisdiction. Or the permittee could opt out of that process and instead choose a preliminary jurisdictional determination that basically said that all waters, all aquatic features on the project if they met the core wetland delineation annual criteria, or they had an ordinary high water mark for their channels that had an ordinary high water mark, could be considered as potentially jurisdictional. We don't know for sure if they're jurisdictional, but we'll let you get a permit as if they were jurisdictional and save yourself all the time of going through the approved JD process, which for some people had started to drag on for months and looked like it was going to drag on for years. Something had to change. That brings us to the Obama administration's approach to solving this dilemma, the Clean Water Rule. Oh, those streams, those ephemeral streams. All my life I've been searching for streams such as these. So the Clean Water Rule, a noble objective. The Clean Water Rule started about 2014. So we had several years, almost 6 years of post-Rapanos uncertainty and the approved and preliminary JD process. But the Clean Water Rule sought to end all that and make a simple, clear, consistent ruling on or definition of waters in the United States. The approach was based on science, agency experience, and of course, all of the Supreme Court decisions that had led up to that point, with a heavy deference to Kennedy's significant nexus test. The science was summarized in a 408-page connectivity report, reviewed over 1,200 scientific studies. There was a light economic analysis looking at how much impact this redefinition would have on the regulated public, but they were heading on public hearings with over 400 public hearings held throughout the nation, and then addressing over 1 million public comments after the draft rule was issued before they issued the final rule. So how did the Clean Water Rule define waters in the United States? The Clean Water Rule came up with 8 categories, similar terms to what was used in the 1986 definition and had been used in the Supreme Court cases. The first 4 are pretty straightforward: navigable waters, interstate waters, territorial seas, impoundments of waters in the United States, all had been used in previous definitions. Tributaries to those waters, as long as that tributary had an ordinary high water mark and a bed and banks, which were defined in the rule. And adjacent waters, which included adjacent wetlands, to all of those category 1 through 5 waters. Adjacent was defined in the rule as bordering, contiguous, or neighboring, which was a familiar definition that had been used before. Neighboring was further defined as a water being at least partially within these distance limits from the ordinary high water mark of a tributary or a high tide line. If you were within 100 feet of an ordinary high water mark and outside the 100-year floodplain, that feature was jurisdictional. If you were within 1,500 feet of the ordinary high water mark inside the 100-year floodplain or within the high tide line of the coast or the Great Lakes, that feature was also considered jurisdictional. No need for a significant nexus test. Do not pass go. Do not collect $200. These 6 categories were considered waters of the United States under that rule. And then there were these other 2 categories, these similarly situated waters and these case-specific waters, both of which had to go through the significant nexus test to prove whether or not they were a water of the United States. Similarly situated waters included 5 categories or landform types of waters that had been at some point, sometimes were considered jurisdictional, oftentimes considered isolated. They were grouped based on the connectivity report, the scientific analysis that was done into these terms, including our own Texas coastal prairie wetlands that are basically all the way down the Texas coast and into Louisiana. And it was decided that if any of those waters within a particular group qualified for the significant nexus test or satisfy the significant nexus test, then all of those similarly situated waters in that group would be considered waters of the United States. So we expected that was going to happen pretty quick. And then these case-specific waters were defined based on another set of distance limits. If you were within the 100-year floodplain, but beyond that initial 1,500 feet of jurisdiction by rule, then you were subject, that wetland or water was subject to a significant nexus test. if you were within 4,000 feet of the ordinary high water mark or high tide line, ordinary high water mark of a tributary or high tide line of a tidal water, your wetland could possibly be jurisdictional if it met the criteria of the significant nexus test. And if you remember the significant nexus test in those days, it was basically a list of about 9 functions that a lot of water satisfy and wetlands satisfy, including flood attenuation, sediment sequestration, aquatic life use, those sorts of things. If a water met any of those 9 criteria, it could be considered significant as far as its effect on the downstream physical, chemical, and biological integrity. So it's sort of a low bar, in my opinion, to meet the significant nexus test. That rule was issued in June of 2015, had an effective date of August 28th of that year, and the day before was subjected to a preliminary injunction by the federal district court in North Dakota. In fact, a whole firestorm of litigation erupted when that rule came out. 18 federal district court complaints, 22 federal appellate court petitions. Eventually, the Sixth Circuit, which is the circuit over here that includes Ohio and Michigan and Kentucky and Tennessee, the Sixth Circuit decided that, and I'm just assuming that it was in order to be efficient and save some of our federal court resources, to consolidate all of those courts into one review in the Sixth Circuit Court of Appeals, and they issued a nationwide stay of implementation of the rule, in addition to the injunction that had already been issued. So it didn't take long before Clean Water Rule Clean Water Rule never really even got out of the chute initially, but then it didn't go away. We'll come to that here in just a second. Why all the pushback? Why was this such a big deal? This is supposed to solve the problem. The Clean Water Rule was going to make a definition everybody could live with and draw these bright lines, and you'll know where jurisdiction is at, and then you can go through the regulatory process with clarity and efficiency. Well, I think the big problem for the Clean Water Rule, one of the big problems, but this is probably the biggest, was that 4,000-foot adjacency limit for case-specific waters. That was a big leap from what was discussed in the draft rule that was put out for public comment. Those distance limits were not included in that draft rule, and I think that was at the heart of most of the litigation against that rule. And just to kind of illustrate that, this is Fort Bend County. If you did a quick GIS exercise with Fort Bend County and you loaded up the National Hydrography data set streams, all of these blue streams on here, and you overlaid National Wetlands Inventory, which are these green dots, and if you're curious about the floodplain, that's the orange area right there. You can see that there's a lot of wetlands that do not fall within the 100-year floodplain, and some that are not even close to some of these stream channels that would be jurisdictional under the post-Rapanos guidance, so possibly a lot of isolated wetlands. If you took just that set of data and assume that those streams might be jurisdictional and have an ordinary high watermark, and you applied that 4,000-foot limit, very little of Fort Bend County, and I would say that, knowing Fort Bend County, none of Fort Bend County would be outside the reach of consideration of a wetland being jurisdictional or water being jurisdictional under the significant nexus test. So you can kind of see why people got a little bit upset. That brings us to the navigable waters protection. So thanks for bearing with me. The Trump administration, from the get-go, and this was a platform, a campaign platform plank during Trump's run for the presidency, was to remove this very, very bad rule. So they went right to work as soon as the president was elected, and Scott Pruitt was confirmed head of the EPA. They started about the business, and I'll talk about that here in just a second. But right about the time, actually, right before Trump was inaugurated, there was this interesting little development happening in the Supreme Court, tied to the National Association of Manufacturers versus DOD case, which was asking whether or not the Sixth Circuit Court of Appeals really had the jurisdiction they claimed to review all of these federal court cases dealing with the Clean Water Rule in one sitting. The Supreme Court agreed to hear that case and make a decision as to whether or not the Sixth Circuit Court really had that jurisdiction. And then they pressed the pause button on it. Donald Trump and Scott Pruitt continued on. They started with Operation Shrink the WOTUS. Their idea was to take Waters of the United States, the definition of Waters of the United States, and apply a new standard that would put it in a nice box tied to the rules of federalism, which we'll talk about here in just a second. So Executive Order 13778 came out. WOTUS shrink began. That order asked or told the federal agencies to repeal the Clean Water Rule and reinstate the status quo, the post-Rapanos definition, until they could replace the Clean Water Rule with a new rule that was more in line with Justice Scalia's definition of waters of the United States from the Rapanos case. And Scott Pruitt went right to work to do it. Immediately, within days, there was an intention to review and rescind and revise the Clean Water Rule as published in the Federal Register. And that took us into this next saga. But wait, the Clean Water Rule was still out there. So the Clean Water Rule returned in 2018. A year later, the Supreme Court got back to the National Association of Manufacturers versus DOD. It came up on their docket, and they decided that the Sixth Circuit Court of Appeals did not have the jurisdiction they claimed, and that any decisions made with regard to Clean Water Act jurisdiction had to start at the federal district court level. That was their interpretation of the Clean Water Act, and it still is today. And so when they did that, the clock started ticking on Clean Water Rule implementation. All of a sudden, the stay was potentially going to be lifted as soon as the Sixth Circuit Court agreed with the Supreme Court or concurred with the Supreme Court. And so EPA did a quick shuffle. It was kind of like watching a football game. And they did a little flea flicker move, and they came up with this delay rule with the intent of putting an applicability date on the Clean Water Rule. Applicability date way in the future, after they would have been able to rescind the rule and replace it with a new rule. An interesting turn of logic. It didn't work. Long story short, the delay rule was also brought under litigation, and the South Carolina District Court stayed the delay rule in August of 2018. And the Clean Water Rule, for a time, went into effect, but only in a portion of the United States. So 22 states at that point in time were subject to Clean Water Rule definition of waters in the United States, and 27 states were subject to the post-Rapanos guidance. Only one state couldn't make up their mind. That was New Mexico. And then it's still debatable as to which way we'll go in New Mexico. But it didn't last. They were able to issue and implement a repeal rule that went into effect in December of 2019, and the Clean Water Rule lived its brief life, and then it died. So everything went back to, and that's the state that we're currently in, post-Rapanos definition of waters of the United States. What's interesting were some of the reasons for the repeal, or some of the reasons that were cited justifying the repeal rule. And I'm not going to, in the interest of time, I'm not going to go into a lot of these issues, but you'll see some of these same highlighted words and same highlighted phrases being brought up in the litigation that's being filed right now against the Navigable Waters Protection Rule. So the replacement rule, the quick history behind the Navigable Waters Protection Rule, similar purpose as the Clean Water Rule, to provide justification, sure clarity, and regulatory predictability. But the approach was a lot different. It was to strike a balance between where the line should be drawn for federal jurisdiction versus state jurisdiction over aquatic resources. It was to enact the law or the rule of federalism. The Corps of Engineers and the federal government should only go so far in their jurisdiction, and then the states should take up the slack, and they should do the rest of the work. It focused heavily, as was expected and dictated by the executive order, on the Scalia opinion on relatively permanent water. And had a pretty good, robust economic analysis, no scientific analysis like the connectivity rule, and the number of public hearings was limited to one in the basement of a conference center in Kansas City, Missouri, back in February of 2019. I was there. It was very interesting. It was a very interesting and surreal experience. Over 800,000 public comments were addressed, so similar number of public comments as the Clean Water Rule. And ultimately, that rule was published under the moniker Navigable Water Protection Rule in April of this year. And that's where we are today. So this rule is getting ready to be implemented, perhaps, in the next month. What does the rule say? Well, the rule, to its credit, is quite clean in the way that it's in the way that it assembled its wording. The wording is very laconic. It's efficient. The waters of the United States are very clearly defined, except for some definitions that we'll get into here in just a minute that I know a lot of us from consulting backgrounds or who are out there helping figure out where this jurisdiction begins and ends will find very interesting. The jurisdictional waters are described in paragraph A of that rule. So you'll hear that parlance a lot with the Corps of Engineers. Paragraph A waters versus paragraph B waters and paragraph C definitions. Paragraph A started off with the usual suspects, the territorial seas, their tributaries. Paragraph A did tie territorial seas and what would be considered navigable waters, or those waters that are susceptible to their use in interstate commerce and foreign commerce, back into the definition. They brought that wording back into the definition, which goes back all the way to the first definition that was done by EPA in 1986. The lakes, ponds, and impoundments of jurisdictional waters and adjacent wetlands. Adjacent wetlands, just to be clear, does not have the same definition as adjacent wetlands did under the Clean Water Rule. They also went into a long list of non-jurisdictional waters, which the Clean Water Rule did as well. And most of these non-jurisdictional waters were waters that were already defined in different regulatory guidance that the Corps had issued over previous years. They were just kind of brought all to the forefront and firmly codified as being non-jurisdictional. Some of these waters that were considered non-jurisdictional, you'll see these phrases pop up over and over again. If the artificial feature, like artificial ponds or stormwater features and things like that, were constructed in uplands or non-jurisdictional areas, they are always to be considered non-jurisdictional waters. But paragraph C talks about all of the definitions that pertain to paragraph A. And I'm not going to go into all those definitions, but there are a few that I would like to highlight, including adjacent wetlands, intermittent, the term intermittent as it pertains to tributaries, lakes and ponds, and then the term tributary and the definition of typical year. These are very important definitions. There are also three key phrases that are used relative to these definitions that you need to keep in mind that came out in the final rule that weren't exactly used or used in the same ways in the draft rule. So there's just a big deal. Inundated by floodwater as it pertains to adjacent wetlands and lakes and ponds and impoundments. Contributes surface water flow as it pertains to lakes and ponds and impoundments, and direct hydrologic surface connection as it pertains to adjacent wetlands separated by an artificial structure. So let's take a look at a few of these things. So adjacent wetlands are those wetlands that have a direct hydrologic surface connection to a tributary. No, that is not the case. And I struck that out on purpose because that was the original definition in the draft rule. The final rule says adjacent wetlands are wetlands that abut or are inundated by flooding of or from a paragraph A water in a typical year. It's got to have some level of inundation by flooding from that paragraph A water in a typical year. It can be separated, an adjacent wetland can be separated by an artificial structure like a dike, a barrier, or something like that. But if that wetland has a direct hydrologic surface connection in a typical year, it is still considered jurisdictional. A tributary, on the other hand, is simply defined as a river, stream, or some other conveyance channel that contributes surface water flow to a paragraph A water in a typical year. And it's got to be perennial or intermittent in a typical year. It cannot be an ephemeral feature. It cannot flow only because of snow melt or precipitation. It cannot flow only because of precipitation. It has to have some other input. A tributary doesn't, this is important as well, it doesn't lose its jurisdictional status if it goes underground or if it's channelized for a certain amount of time, or it has to go around or over an artificial or natural feature, which is consistent with previous Corps of Engineers guidance. But the definition of intermittent is a little different than what we've seen in previous Corps of Engineers definitions. The definition of intermittent means that you've got to have water flowing continuously during certain times of a typical year, and those certain times is not defined, more than in direct response to precipitation. And that would seem to insinuate groundwater. It has to have an input by groundwater. But the rule also, and I think this is in the preamble, also talks about snowpack. Snowpack melt in the mountains could provide intermittent flow for a channel. The question remains, and we'll see, are there other sources? What about artificial sources? What about wastewater treatment plants? We don't know. It's not discussed, but we may see that if this rule goes into effect. And then perennial meant surface water flow continuing continuously year-round in a typical year, supposedly. Lakes and ponds, impoundments, and those jurisdictional features were still considered jurisdictional, as I said, if they contribute surface water flow to those paragraph A waters in a typical year. Also, oddly enough, they're also jurisdictional if they're inundated by flooding by those paragraph A waters in a typical year. So they can be jurisdictional waters in either case. And they don't lose their jurisdiction, as I said, if they go underground or they have an artificial feature or something like that. What does the term typical year mean? Well, a typical year is defined as a rolling 30-year period of basically averages, normal periodic range, rolling 30-year period of average climatic conditions for the watershed that you're dealing with. There's a lot of guidance, well, not a lot of guidance, but there's some pointing to guidance as to how to come up with the typical year numbers in some of the publications that EPA put out associated with the rule, and we'll talk about that real briefly at the end of this presentation. So here's the graphic, what you guys have probably been waiting for as I've droned on and on about all those words. All of these features at some point in time were considered waters of the United States under those definitions that I've just laid out for you. Everything, or in some way were tied to the definition of waters of the United States, like the designation of a floodplain or ditches or whatnot. In the post-Rapanos world, under the Rapanos guides, these were the categories that were considered jurisdictional or were dealt with on a case-by-case basis using the significant nexus test. Jurisdictional in blue, significant nexus test in gray. When you went to the Clean Water Rule, that expanded possibly dramatically out into the landscape. And a lot of the things that were considered case by case under Rapanos were now considered jurisdictional by rule. And a lot of things that were considered non-jurisdictional under Rapanos were now considered case by case under the Clean Water Rule. Under the Navigable Waters Protection Rule, that jurisdiction is severely curtailed, is brought back dramatically. Admittedly so by the rule, under the idea of federalism and letting the states deal with everything beyond a certain point of jurisdiction under the Clean Water Act. And a lot of these features are now tied to these key phrases that I described before in a typical year. So it's important to know how a feature like a wetland that we would have thought was jurisdictional before would be considered jurisdictional under this rule. It's going to depend on its tie to the hydrology of the adjacent paragraph A water or tributary. So that brings us to the, where I'm going to wrap this up for you guys and talk about where this is headed. Perennial and intermittent waters and adjacent wetlands only. This is my only soapbox slide, so I'll keep it brief. This is a picture of my daughter. We're in a canoe. We're on our property out here in Waller County. We're in a wetland that is normally dry, and it is the day after Hurricane Harvey finally stopped dumping about 60 inches of rainfall on the Houston, Galveston Metroplex area, a day we all remember and can't get out of our brains. The reason why my daughter is smiling as we're paddling around this wetland that's normally dry is because it's holding about 15 acre-feet of water that could have, if that wetland was not there, been in her house. So she's very happy that the wetland is doing its job and the water is not in her house. However, that wetland, because of its location on the landscape, was not jurisdictional at that point in time and would certainly not be considered jurisdictional under the Navigable Waters Protection Rule. Why am I saying that? The only reason I'm saying that is because I also wonder what Congress meant by the scope of the Clean Water Act. Did they really mean it to limit to just navigable waters, or did they mean the act to pertain to features that really had an impact on not only our downstream navigable waters physical, chemical, and biological integrity, but just the nation as a whole and people's safety? So at any rate, what would happen if we lose the standard? The economic analysis for the Navigable Waters Protection Rule, when the draft rule came out, actually goes into great detail on what would happen and goes into a lot of the potential effects of retracting jurisdiction, federal jurisdiction, under the Clean Water Act and leaving it to the states. And I'll leave that to you to look at those, and you can digest that because in interest of time. But suffice it to say, there was a significant amount of a potential effect from implementing this rule. The rule is scheduled to go into effect on June 22nd, 2020, but we still have three main things to consider: litigation, legislation, and the potential role of the states. Litigation, what's going on right now? Well, as of the time when I put this presentation together, there were at least 7 actions or motions that have been filed, cases that had been filed challenging the Navigable Waters Protection Rules implementation. Well, the last one, or one of the most recent, was a consortium of 17 attorneys general filed in the Northern District of California in San Francisco, and covering these states, these highlighted yellow states. So California, Oregon, Washington, a lot of the East Coast states and the Northeastern states, several of the Midwestern states, and New Mexico again. All of these states filed suit. All their attorneys general or some faction of those states filed in this lawsuit to stay the Navigable Waters Protection Rule. The reasons, the arguments that are listed in all of these court cases are similar, and here's a list of them. But the top ones are that the Navigable Waters Protection Rule did not adequately follow the Administrative Procedures Act, a similar argument that was made for the Clean Water Rule. There also that the Navigable Waters Protection Rule did not appropriately address the Kennedy's significant nexus test that was brought up in Rapanos. But perhaps one of the most major challenges to the rule is the claim that the rule did not comply with Section 7 of the Endangered Species Act, which we've seen this argument come up in other places recently as well, relative to the use of nationwide permits. All of these rules, because of that Supreme Court case in 2018, must be tried initially in district courts. And those district courts have a history of overturning agency rules. Will this result in another nationwide permits or a nationwide stay of the Navigable Waters Protection Rule, or will it result in a patchwork of states that have enacted it versus those that are still under Rapanos, like what we saw for a time in 2018? We don't know. Eventually, could it end up back at the Supreme Court of the United States? The answer to that is absolutely yes. And we have some hints into what might happen there. I'll talk about that here in just a second. This is a cool slide because it tells you kind of where the pieces lie as far as the appointments of our current Supreme Court and how many were there during the Rapanos case. So you see, you've got 5 Republican presidential appointees, you got 4 Democratic presidential appointees. The makeup is much different than it was under Rapanos. So what might happen? Well, a little hint. In the latest, one of the latest Supreme Court cases to deal with Clean Water Act issues, not related to definition of waters in the United States, but related to the discharge of a pollutant into a groundwater and then into a navigable water in the United States, County of Maui versus Hawaii Wildlife Fund, interestingly enough, 6 judges agreed with the prior court rulings that the discharge of a pollutant into a groundwater that made its way in a functionally equivalent way to a direct point source discharge into a water in the United States should be considered or should be required to get a permit under Section 402 of the Clean Water Act. This might be some insight into what might happen if the Navigable Waters Protection Rule makes its way to the Supreme Court. However, there is a caveat to that. Justice Kavanaugh did issue a slightly different opinion in his concurrence with the majority, and he did make sure and maintain his thought that the definition of waters in the United States should be tied to the Scalia definition from Rapanos. Legislation, and I know I'm running a couple minutes over, but I'm going to wrap this up for you guys. Legislation. There is a Clean Water for All House bill that has been proposed by a couple of representatives in the House right now. We'll see how far that goes. That would seek to prohibit the Navigable Water Protection Rule going into effect. Don't know if that really has any real potential for getting past the Senate and becoming law, but it is a nice gesture. What about the states? Well, long story short, it's very complicated. There are a lot of states that could fill the gap, so to speak, that was left by a retraction in the definition of waters in the United States. There are a lot of states that have significant barriers to taking on that additional jurisdiction, not the least of which is funding and manpower and staffing. But this is the way that the economic analysis from the Navigable Waters Protection Rule predicted things might go. So perhaps these states, the states in green, might be able to continue or expand jurisdiction over those waters that were no longer jurisdictional. Those are the states in green. Not likely are the states in red. Not really a big surprise. The landscape changes slightly when it comes to pollutants other than fill under Section 404. Under Section 402, you may get a few more states that do not extend their jurisdiction beyond what they have right now. So about half and half. If you want more information on the Navigable Waters Protection Rule, particularly on its implementation for practitioners and for consultants out there, I highly recommend going to the EPA's website and looking at especially this implementing the final 2020 Waters in the United States definition little fact sheet. It's got some really interesting terms in there and use of different on-site visual observations and field-based indicators in order to determine some of these hydrology connections that are listed in the Navigable Waters Protection Rule. And with that, I know I'm about 4 minutes over, and I apologize, Jim, but I am done, and I'm happy to answer any questions that y'all might want to entertain.
Matt, thank you very much. That was very interesting, very comprehensive, and I really appreciate it. So we did get a question that I'd like to pose, and so the question comes from Courtney Klaus, and the question is, why did the Clean Water Rule have the 4,000 foot limit for adjacent wetlands and not another number?
That is a really good question, Courtney. And that was the question that was brought up in a lot of the litigation that was filed on the Clean Water Rule. And I have my suspicions on where that may have come from, but I do believe that, because I've heard this question asked before, there was a statement that was made in the connectivity report that was used, in the development of the Clean Water Rule, that actually used that number as sort of the average or maximum limit to which you might expect waters to lie on the landscape that could in some way significantly affect the downstream physical, chemical, and biological integrity of the nation's waters. I think that it came out of the connectivity rule, but I don't have the page and the paragraph of exactly where that statement was at.
Okay, thank you.
No problem.
I have one question. It stems from a conversation you and I had yesterday, because you mentioned, and I saw it pop up in a slide here, you mentioned that there's some things going on with nationwide permits, and
Oh, yes.
I'm just curious how that might fold into this in your opinion moving forward.
Wow, that's a whole nother webinar, Jim. There's a lot. There are a lot of questions right now about how nationwide permits can be authorized, as far as their coordination as there is required to be coordination with U.S. Fish and Wildlife Service under Section 7 of the Endangered Species Act, and whether or not the programmatic reviews that have been done for nationwide permit releases in the past were adequate, and whether or not they can legitimately move forward with an adequate programmatic review in order to fix the current situation that we have with the nationwide permits, or specifically with nationwide permit 12 as it relates to oil and gas pipelines right now. That issue has a lot of potential repercussion on how this rule would be implemented, if it is implemented, and how the coordination under the Endangered Species Act with U.S. Fish and Wildlife Service proceeds in Clean Water Act permitting in the future. I'm not an endangered species aficionado. I know some people who are, and who are deeply engaged in this issue, but I would really watch that close. I'd watch the news articles and see where litigation is headed that is specifically using that argument in order to make a claim against either this rule or the use of a nationwide permit.
Okay, all right, thank you for that. We have another question. This one comes from Aaron Brewer. He asks, do you anticipate any difference in how intermittent streams are defined in the near future?
Yes, and that's a really good question. So going back to that fact sheet, Aaron, dig into that fact sheet, and this will help you, because I think there are a lot of features out on the landscape that have casually been considered ephemeral, that if you dig into some of the field-based indicators, or you talk to some of the core rank and file staff from their district staff, that under this rule they may reconsider whether or not those features are ephemeral, and they may consider them intermittent. That definition of intermittence doesn't really give a time limit on how long water has to flow through there. It just says the source of the water has to come from more than something that's just precipitation driven. There are lots of field indicators that can help you determine whether or not it's just precipitation, or if there indeed is some level of groundwater influence into a channel that, before we would have walked across and looked at it and said, that's ephemeral. Now you really dig in and you look at some of these field indicators, you may discover that Well, under this rule, under the way they defined it in the final rule, it could be considered intermittent. And I would not be surprised to see a lot of districts expand on what they considered intermittent beyond what they presently consider intermittent. Good question.
Okay. One last question, and this comes from Brandon Weem, and he says, is there any guidance on how the 100-year floodplain is going to factor into the NWPR? Is there potential that wetlands located within that portion of the watershed might be considered adjacent?
That's a good question too. So if you think about the way that this rule is written, there's no mention, and there may be discussion about it in the preamble. I have to go back and check. That's a really good question. But just on the surface, the rule doesn't really talk about the floodplain itself. And if a feature, if a water or wetland is located in the floodplain, it's jurisdictional. If it's not, it's not. It only talks about adjacency being established by that flooding from a tributary, and the tributary has to be something that's intermittent or perennial and has ordinary high water mark. So if the feature, regardless of whether it's in the floodplain or not, is subject to that flooding from that adjacent water, that paragraph A water, then it is considered adjacent. If it's not, it's not. And so if you had a wetland that was in the 100-year floodplain, that most of us would think surely that's adjacent, that's jurisdictional, but there's no tie to in a typical year some sort of flood event coming out of that adjacent water, then under this rule it would arguably not be jurisdictional. So our rule of thumb, especially in the Galveston district, for the 100-year use of the 100-year floodplain, and as far as I can tell, would not apply using this rule.
Need to turn my mic on. Thank you for that. Thank you. So in the interest of time, I do see a couple other questions and comments have come in, but we are well after 1 o'clock. What I would like to do is we will post written answers to these questions. Matt, if you're willing to work with me on that, I would really appreciate it.
Sure, I'll be happy to, Jim. Yep.
So yeah, okay, thank you. We'll post those and we will send them out to everybody who registered for the meeting. Craig has noted in the chat area that he is going to post a recording of this presentation along with the slides that Matt graciously provided to us. So that will be available for those of you who attended today as well. Again, Matt, thank you so much. I've known you a long time, and I recognize you as somebody I would turn to as a knowledgeable expert in this area. And this is really pertinent. It's I've talked about this is a really big deal, and it is a really pertinent issue in front of us right now. And I know it changes the way I even interact with my own clients moving forward, and yeah. It's significant. So So in any event, thank you so much. We really appreciate your taking the time today to share this with us. Everyone on the call, everyone on the conference today, thank you so much for taking the time to join us, for posing questions that I see are still continuing to come in. So I really appreciate that. If you're not able to pose a question, but you think of something over the course of the day, you can certainly reach out by sending an email to me or at president@taep.org or to admin@taep.org, and we will compile those and pull that together. I would again like to say thank you to everybody. We hope you've enjoyed this. I would encourage you to keep an eye on our website. We do intend to continue to do this on a monthly basis moving forward. I would like to say thank you to the volunteers and folks who work behind the scenes to put these things together. We did have some board members on the call today: Pam Embody, Kathy Garland, Latrice Babin, Allison Sorato, and then Craig, of course, who really does so much work behind the scenes, and I just really am grateful for that. So thank you for all of that. I did notice when I was looking at the registration page that there were a few of you who made donations as you were registering for today's meeting for the that we can put towards our scholarships. So on behalf of TAEP, on behalf of the students that we serve, I am very grateful for that, and I thank you very humbly. And if there's anyone who would like to support us in that way, we of course would always very much appreciate that. So with that, again, thank you very much to Matt. Thank you to all of you, and I wish you continued success moving through this time frame. I know it has been really difficult for a lot of folks, but I appreciate you're out there still doing good work and keeping in contact with one another, and we look forward to seeing you again in the very near future. So do please keep an eye on our website for more events. Thank you so much. Matt, thank you again.
No problem, Jim. Thanks a lot for having me. You have to take care.